Oathkeeper Rhodes, demand trial by court-martial on Monday, October 17, 2022, in a continuation of my belief that if you were a member of the military, you're still under military justice. It's not just my belief, it's a belief of the Supreme Court. And so in this case, the Oath Keepers was founded in March 2009 by Elmer Stewart Rhodes, a Yale Law School graduate, former U.S. Army paratrooper, and former staffer to Republican Congressman Ron Paul. A perfect candidate to test this stuff out because he finds himself in federal court now in the District of Columbia answering for the shenanigans of January 6th, right? And he's a law school graduate from Yale, so he ought to understand the things I'm about to tell him because he's a U.S. Army paratrooper. Stewart, you are subject to the Uniform Code of Military Justice, which means you're not subject to civilian law. So, Soldier for Life Rhodes, you're a lifelong subject of the UCMJ. It is unconstitutional and a violation of military due process for you to be charged for a crime by the indictment of a grand jury. Your accuser must file charges and specifications in accordance with Article 30 of the UCMJ, and an Article 32 investigation must be performed before you can be tried by court-martial. And Article 14 requires the military deliver you to the civil authority. And this is all starts with the Fifth Amendment, where it talks about no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces. Well, Stewart, you're still in the military. They never let you go. You're a soldier for life. And I am Staff Sergeant Robert Allen Orlowski, U.S. Army veteran, another soldier for life, also known as Rob Ryder. My email address is quarterrecord@AOL.com, and you can find me on YouTube at Rob Ryder, ROBBBRYDER. So I'm just going to show a number of things I've shown in past videos, but specifically geared towards the Yale Law student here, or Yale Law School graduate, who should be able to interpret it for himself and, do something with it. So if somebody could let Elmer Stewart Rhodes know about this information, he would be the one that would have the, education to help understand it completely. So let me get started here. Hang on a second. So I'm going to start with this little blah blah that I wrote to these three different esquires that are apparently representing Elmer Stewart Rhodes, in which I said Elmer Stewart Rhodes III is subject to military justice and cannot be charged by indictment. Now, I didn't just say that, of course. That's Constitution says it. Esquire, be advised, you are receiving this information because according to this particular case, 1:22 CR 15, which is in the District of Columbia, you're representing Elmer Stewart Rhodes III. It's a violation of the Fifth Amendment of the Constitution of the United States for a veteran Rhodes to be charged with a crime by indictment of grand jury. Veteran Rhodes is entitled to military due process under the Uniform Code of Military Justice, which requires his accuser to sign and swear charges and specifications in accordance with Article 30 of the UCMJ before a commissioned officer authorized to administer oaths required by military justice, who will then order an investigation under Article 32 of the UCMJ before referral of charges and specifications for trial by general court-martial. Now, I would say that most people in the military don't know this or have served, and, it's really your fault because you need to have read the UCMJ. You're required to know the UCMJ. Go figure. In the opinion of the Supreme Court of the United States, just as military society has been a society apart from civilian society, so military law is a jurisprudence which exists separate and apart from the law which governs our federal judicial establishment. You find that in Burns versus Wilson. And to maintain the discipline essential to perform its mission effectively, the military has developed what may not unfitting be called the customary military law or general usage of military service. Right? Martin versus Mott. So Article 2 of the UCMJ identifies the various classes of persons subject to military justice, and this list includes anyone who swore an oath of enlistment or a commissioned officer. 50, so this would be Title 50, United States Code, Section 4012, which is about certificates of service, persons reported missing, provides that the Secretary of the Army can sign a certificate of service to act as prima facie evidence of Veterans Rhodes' military status and remove all doubt if he is or is not subject to military justice. So there's absolutely no reason you, the representatives of Veterans Rhodes, cannot prove he is subject to military justice and not civilian justice. Veterans Rhodes accusers are using an unconstitutional civilian court process, and any esquire participating in this conspiracy to defraud the United States aids its enemies and commits an act of treason. So fix this clusterfuck today. We veterans are in expectation of you, representing Elmer Stewart Rhodes III, to demand his immediate acquittal from this unconstitutional proceeding that made Veteran Rhodes a defendant. So if you're somebody who can get Stewart's attention, you'd want to tell him to go look at Title 50, United States Code, which is War and National Defense, subsection 4012, Certificates of Service, persons reported missing, where it says that in any proceeding under this chapter, a certificate signed by the Secretary, in this case, Secretary of the Army, concerned is prima facie evidence as to any of the following facts stated in the certificate. Right, that the person named is or is not, has been or has not been in military service. Well, that'll settle the matter. What's the Secretary got to say? Right, and then you have these other attributes on there. And of course, you want to have all that stuff on the certificate if you can get it. Well, I've not been able to get one of these myself yet. I'm just saying, well, here it is. It's in Title 50. Stuart, you're the frickin' Yale Law School graduate. How do you get a copy of it? I'd like to get a copy of mine if you could tell me. But I can also tell you, they say, well, you got a certificate of discharge, right? Here's your honorable discharge certificate. All right, so here's, supposed to be mine. One of mine. I re-enlisted afterwards, or prior service went back in, so I should actually have two of these, and I don't know that I do. I just have the one. But as you can see, it says I was honorably discharged from the Armed Forces of the United States of America. Well, if I look at the DD Form 4 that I would have signed, this is my agreement, my contractual agreement with the Armed Forces of the United States, I could say, well, I wasn't discharged from the place that I enlisted. Right? This is Armed Forces of the United States of America. That's where I was discharged. But no, I entered the Armed Forces of the United States. Obviously, they're not the same thing. It looks like there's some kind of scheme going on. I wonder if that is a possibility. Now, if you were a commissioned officer, when you did your oath of office, it would be on this form similar to this. I don't know if this is for just the Army or not. Yeah, I think it is just the Army. But as you can see, that this form will be executed upon acceptance of an appointment as an officer in the Armed Forces of the United States. Right? It doesn't say anything about United States Army. Right? In fact, if we go and we look at what the Armed Forces of the United States is, Armed Forces of the United States, it says the term Armed Forces of the United States or Armies of the United States is also the legal name of the collective land forces of the United States. Right? There is no United States Army. That may be a term that's used, but it's not the legal name. The legal name is the Armed Forces of the United States. So if this certificate that they gave me is supposed to be legal, they'd have to use the legal name of the United States, Army of the United States, not United States Army. So this is just simulating the legal process to make it look like I've been discharged, which I haven't been. Now, a lot of service members who, when they look at their DD-214, if they've served less than, I believe it's 8 years, it'll say on their DD-214 that they were discharged to the reserves. It doesn't say anybody being discharged from the military. And so don't let them bullshit you. You're not out of the military. Right? And the proof, it's easy enough to prove. Make them get this certificate. Right? Because you're going to find out, I believe if we were to get this, we're going to find out we're still being paid to this day. And I've covered all the reasons in other videos. I'm not going to go into it again now. But, it is what it is. So then if we go to the UCMJ and we start looking at, well, what does it say? In Article 2, it talks about persons subject to this chapter. And the very first line is members of regular component of the armed forces, including those awaiting discharge. Well, we haven't been discharged yet. Even though our term of enlistment may have been over. We agreed to sign up for 8 years or whatever, and it's over. But we haven't been discharged. So we're still subject to it. So that covers it. But you can go down here and say, well, retired members are covered, right? Whether you're a retired member of the armed forces or a retired member of the reserve component or a regular component, right? Either way, you're under it. Prisoners of war, and in a time of war, all these other people. So there's lots of people. Wherever the gold fringe flag is, I'm saying is somebody who's subject to the UCMJ, but we'll save that for a different time. But for the enlisted, here's the big one, right? The voluntary enlistment of any person who has the capacity to understand the significance of enlisting in the armed forces shall be valid for purposes of jurisdiction under subsection A. And a change of status from civilian to member of the armed forces shall be effective upon taking the oath of enlistment. So once you took your oath of enlistment, your status changed from civilian to member of the armed forces, which makes you subject to military justice, not civilian justice. Now, if we go back to our contract for the enlisted, right, and you go to subsection 9, right, for all enlistees or re-enlistees, right, my re-enlistment agreement is more than an employment agreement. It affects a change of status from civilian to military member of the armed forces. As a member of the armed forces of the United States, it did not say armed forces of the United States of America, like the damn discharge certificate says. As a member of the armed forces of the United States, I will be required to obey all lawful orders and perform all assigned duties, yada, 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 yada. Then we get to 5. Entitled to receive pay, allowances, and other benefits as provided by law and regulation. Well, one of those things is a Geneva Convention identification card. Because if you're in the military, you have to have a Geneva Convention ID card because it's required by the treaty. It's international law. So the fact that we're denied our Geneva Convention ID card is a violation of international law. But if you go tell that to an esquire, they don't really care, right? Because they're in the United States of America. They're not in the United States. The United States of America is a dominion of King George III and his successors, which by the Treaty of Peace of 1783 has a right to be in the United States. But it's not the United States. It's just a private society in the United States. Now, that private society of fucking schemers has, through threat, coercion, duress, entrapment, bribery, whatever, gotten official records to be changed to show that we, voluntarily agreed to be in their jurisdiction. That's what they would say. But we didn't. Right? If you join the military, you are under military law, military justice, under the Armed Forces of the United States. And this place here, Armed Forces of the United States of America, does not exist. So if you could, write this down and, just search it. It's easy enough to find online. I say Google search, but you don't have to use Google, right? Just military courts, court-martial, military courts martial under Military Justice Act of 2016. And you'll find this Congressional Research Services Bulletin. And these are like, attorneys that put a little meat to the bones on whatever Congress has decided. Again, that's what they say. And what does it say here? The very first in the summary of what this is about. The Supreme Court has called military justice system of justice separate from jurisprudence in civilian courts. Members of the armed forces are subject to rules, orders, proceedings, and consequences different from the rights and obligations of their civilian counterparts. Accordingly, it might be said that discipline is as important as liberty interest in military justice system. The Constitution specifically exempts military members accused of a crime from the Fifth Amendment right to a grand jury indictment. It's unconstitutional to try you by an indictment. From which the Supreme Court has inferred there is no right to a civil jury and a court-martial. However, in part because of different standards provided in court-martial, their jurisdiction is limited to those persons and offenses the military has legitimate interest in regulating. And as it turns out, the military has first right of refusal to anything that's been offered. As far as whatever's been violated, they can decide if they have jurisdiction because they have these, all-encompassing clauses in the UCMJ. Sort of like these right here, the general article, Article 134, though not specifically mentioned in this chapter, all disorders and neglects to the prejudice of good order and discipline in the armed forces, all conduct of a nature to bring discredit upon the armed forces and crimes and offenses not capital, of which person subject to this chapter may be guilty, shall be taken cognizance of by a general, special, or summary court-martial, according to the nature and degree of offenses, and shall be punished at the discretion of the court. You cannot be charged by a civilian court. Then we go down to, where's the other one? Oh, conduct of becoming an officer, right? A commissioned officer, cadet, midshipman who is convicted of conduct on becoming of an officer or gentleman shall be punished as a court-martial may direct. So, all this stuff is covered by the military. They have the right to decide if they have jurisdiction or not. If they don't have jurisdiction, or they don't want to, and they wanted to release you to the civilian government so they could do something to you, well, delivery of offenders to a civil authority. Under such regulations, the secretary concerned may prescribe a member of the armed forces accused of an offense against civilian authority may be delivered upon request to the civilian authority for trial. Right? So the military has to deliver you after it's been requested, and they agreed. And all that shit's supposed to be done by a regulation. So, somebody telling you to show up at court isn't quite good enough. And one last proof, right, that you're still in the military is, again, this is for the Army, right? An Army Regulation, AR 600-8-22. Google that. You can find your own copy. In Section 6-20, it talks about lapel buttons for service. And you got it for World War I and World War II, and then prior to 1939. Then you get down here to this Army lapel button. So now it says the Army lapel button is a gratuitous issue item made up of gold-colored Minuteman on a red enamel disc surrounded by 16-pointed gold rays with an outside diameter 9/16 of an inch. Personnel who have left the Army under honorable conditions. So in other words, if this document is supposed to be valid, it says I left under honorable conditions, right, are eligible to wear the U.S. Army lapel button. Stop again, right? Not the Army lapel button, but the U.S. Army lapel button. Commanders will present the U.S. Army lapel button to Army personnel at an appropriate ceremony before their termination of service prior to retirement eligibility. The U.S. Army lapel button is gold metal consisting of black background displaying a black star surmounted by a white star. Attached around the device is gold-edged black circle with a scroll inscribed "Soldier for Life" below in gold. Well, that seems pretty self-explanatory. If you were discharged from the military, they're supposed to have a ceremony before you left and give you your U.S. Army lapel button. Let's take a look at one. Well, here we are, the U.S. Army Soldier for Life lapel pin. It says for veteran, but they call it what they want. But this is what it's supposed to look like. This one here with the, the Minuteman, that's the U.S., that's the Army lapel. If you're still in the military, right, this would be something that you would wear if you were in civilian clothes and, to show that you were in the military. You'd put that on your lapel. Well, this is the one that we, veterans, are supposed to have to put on our lapel. But I never got issued one. It doesn't list my DD-214. Again, this is an award, right? So all awards are listed on your DD-214. I never got one. So, again, that's all I really had to say on this whole subject. But I wanted to direct it towards Oathkeeper Rhodes, because he's a Yale Law student graduate. Jeepers. Pretty self-explanatory, brother. You need to, stand up in court, demand trial by court-martial. Right? You need to call some commander. You need to call you need to call Ron Paul and tell him. He can contact somebody. But all it's going to take, Stuart, is one signed order by a commissioned officer, and we will pierce the veil in this bullshit, and we'll never have to deal with it again. So I hope you're the man, because you're on the inside right now. You're on the hot seat. Okay, everybody have a great day, and you know some way to get this to Stuart Rhodes or Congressman Paul, please do. And I'm going to leave it there. Have a great day.